My name is Matthew Morrison and I'm a solicitor in the employment team here at Thomson Snell and Passmore. I'm joined today by Ben Stepney, who is a partner in the team, and Ben and I will be talking today about the allocation of tips. So we will be recapping the rules covering how employers allocate tips among workers and discussing some upcoming changes to tipping rules which are expected to come into force in October this year. So Ben, firstly, could you please provide an overview of the current rules?
So the current rules prescribe how employers have to allocate tips amongst their workers, and they oblige workers to ensure that tips are allocated fairly. And the current rules are set out in legislation and also a code of practice that goes alongside it. That's a slightly more user-friendly read. The rules apply to all tips, so that's tips, gratuities, service charges, which the employer exercises control over collecting them and distributing them. So these rules primarily apply in the hospitality sector, as those are the sectors where you're most likely to come across employers who are regularly taking and allocating tips.
And what practical guidance does this code of practice contain about the allocation of tips?
So the main principle is that tips have to be allocated fairly and transparently. So what this means for employers is that they must take steps to seek broad agreement with workers about how tips are going to be allocated, normally by way of consultation. They also need to maintain written records of how tips have been allocated amongst their different workers, and have got to keep those records for at least 3 years from when the tips were paid in the payslip at the end of the month or week as applicable. And they also have to ensure that tips are paid no later than the month following the month in which the tips were earned.
So please could you provide some further detail as to the meaning of fair?
Of course, so the code of practice gives employers some guidance about how the allocation of tips will be deemed to be fair. And it will vary from restaurant to restaurant, hotel to hotel, but the factors that will be taken into account would include the type of work the person's doing, the role they're in, the level of their basic pay and how they're engaged. Are they employees or workers? Are they on a 0 hours contract, for example? The amount of hours worked during the period when the tips are received, that goes to the point about fairly allocating them between different workers. That individual's performance or the performance of the team they're in, the department they're in. It also takes into account the workers' seniority and responsibilities they have. And also takes into account the customer's intentions. Did they intend that the tip would go to a specific worker, or did they understand that it might go to the whole team who are working that shift?
And so what is required in order to meet that transparency requirement?
Well, that requires the employer to have a written policy about how they will allocate tips, and it must be available to employees, and any updates made to that policy has to be communicated to the employees. And the employer has to make sure that new recruits are given the policy or access to the policy as part of their recruitment as well. So the employer needs to show not only that it has a policy, but it's made employees aware of where it is, where they can find it.
And what could happen in the event that an employer doesn't follow the guidance?
Well, worst case scenario for the employer is that they could find themselves facing an employment tribunal claim by an employee, a group of employees, or trade unions or representatives on their behalf, alleging failure to fairly allocate tips. And if a tribunal finds in favour of the claimants, it can award compensation to the claimants payable by the employer. There's also the reputational risk for the employer. Tribunal claims are public hearings, and a finding against the employer that it has not been fairly allocating tips to what are often relatively low paid workers can lead to adverse publicity.
So as mentioned, there are some upcoming changes to tipping rules that are expected to be introduced in October of this year. Could you provide an overview of those?
Of course, this is actually part of the government's Employment Rights Act, which is implementing throughout this year lots of other quite radical changes to employment law. So as part of the new Act, employers will no longer be able to introduce or change a tipping policy without first consulting workers or unions where the employer recognises unions. So currently consultation is strongly encouraged, but going forwards from October this year, 2026, that consultation is going to be mandatory. Secondly, there will be an obligation to review the employer's tipping policy every 3 years and to carry out that review alongside workers or trade unions. There will also be stronger enforcement for compliance failures. If a worker incurs losses as a result of the employer's failure to comply with the obligations on allocating and distributing tips, then tribunals can award compensation of up to £5,000 per employee. And as I mentioned before, there's also the reputational damage to take into account if you as an employer find yourself on the receiving end of a tribunal claim that you haven't allocated tips amongst your staff in a compliant manner.
So finally, how can employers ensure compliance?
So we recommend to ensure compliance with the current rules, employers ensure that they have appropriate systems in place to actually distribute and record the allocation of tips. The employer needs to make sure that it has adequate records of how those tips have been allocated and that it retains those for 3 years. And to ensure staff and managers are trained so they know that a consistent approach is taken towards allocating tips. And also to make sure that tipping policy is easily available to all of the workforce who are affected by it. To get ready for the new rules, we recommend that employers get into the habit of periodically reviewing how they allocate tips to ensure they stay compliant, and at the very least to review their tipping policy and process at least every 3 years. And as part of the new rules, employers will also need to consider who they are consulting with. Is it the workers directly, maybe with a small workforce, or in a larger organisation that recognises a trade union, it might be with a trade union or a body of worker representatives.
Thank you very much for your insight, Ben. And if you require assistance with employment law or have any queries about the new guidance, please do not hesitate to get in touch. Thank you very much for listening.